Thank you for joining us. The following presentation is from a webinar titled Risky Business: Navigating the Legal Aspects of Social Media in the Workplace, originally produced on March 20th, 2014. The presenters are Suzanne Sentman and Reed Horanburg with McKonly Asbury, along with featured guest Todd Shill, employment law specialist from Rhoads Sinon. Enjoy the presentation and visit us online at www.mackas.com for information about our future events and upcoming webinars. Today we have a few great hosts and guests with us. Our lead host is going to be Suzanne Sentman. Suzanne works with us at McKonly Asbury and is an HR generalist, but she also serves McKonly Asbury internally as well as performs HR consulting for clients. My name is Reed Horanburg, and I'm also with McKonly Asbury. I have a background in IT and also work with our digital media and marketing. Our featured guest today is going to be Todd Shill. Todd is an attorney with Rhoads Sinon and has a focus on employment law and litigation. He has over 20 years of experience and specializes in social media in the workplace. Before we get started, let's give a little bit of background about our firms. McKonly Asbury is an audit, tax, and advisory firm with a regional presence in Pennsylvania. We serve a wide variety of clients. We also have special capabilities in HR consulting and job placement. We have been ranked numerous times as a best places to work and a best accounting firm. Rhoads Sinon is one of Central PA's premier regional firms providing sophisticated counsel throughout the Commonwealth of Pennsylvania. They have a wide variety of areas that they specialize in.
Thanks, Reed. Before we get started, I wanted to briefly highlight what's on the agenda for today's discussion. Obviously, if you've signed up for this topic, you realize the importance of it. It's a very hot topic. It's an ever-changing one that we'll hear more from Todd as he walks us through all the different facets and angles. But basically, looking at the prevalence of all social media that's out there, the fact that I believe that the numbers are now reflecting that there are 1 billion monthly active users on Facebook. I think I saw a statistic that said that YouTube has 1 billion unique visitors per month. So this is a reality for employers out there. Not only are we going to talk about just the prevalence of social media, but just some facts with what you can or cannot do when it comes to monitoring employees. Also look at just some practical applications for employers. All of you obviously are trying to attract the best talent that's out there. So can you use social media when it comes to hiring? Looking at some noteworthy developments. Obviously, Todd has his ear to the ground with what's happening in the court system. And then also some takeaways. If you're an employee, what is safe amidst the backdrop of social media? What can you do? What should you not do? What should you think about before you make one of those posts? And for employers, what are some best practices? So let's start by just talking about social media and its prevalence in the workplace. And Reed, from an IT perspective, I'm sure you might even have some more names to add to that list at the left. Obviously, we all have heard of MySpace, Facebook, LinkedIn, Twitter, maybe some less frequented sites, I should say, would be things like Reddit or Snapchat, Pinterest. But the reality of it is that 75% of employers are using social media for business purposes. And this would include advertising, whether it be on Facebook, perhaps encouraging even their employees to go out on LinkedIn and establish that social network for advertising and to get product knowledge and information out there on the internet. But also, it's interesting to know that while most employers recognize the value of social media, they also realize that employees are going to access social media for perhaps non-business reasons. And that is why we're here today, because we're really talking about the commingling of business and personal use and the potential risk that it could pose to both employers and employees. So something that I hear from both in-house here at McKonly Asbury and then even with clients, and really regardless of how large or small of an employer you are, is that against all the social media that's out there and all the avenues that folks have for discussing employment and such, a lot of folks come back and say, hey, what can I do? What action can I take as an employer against, an employee for making it known on Facebook, what it's like to work for our organization? So, Todd, as far as talking about what you can or cannot do as an employer, I'm sure you have lots of advice for us today.
Yeah, well, first of all, thanks for having me here today. I'm happy to be here and discuss a topic that is truly an endless topic. I mean, it's incredible that every day you wake up and read the news and there's another story about a termination that occurred via social media or about social media that resulted in a lawsuit. So it's constantly growing. If you go back and you look, even 5-6 years ago, I think the advice that employment lawyers were giving to employers was very simple. Yes, you can fire employees for whatever they say on social media. No different than if they said it in the break room, around the water cooler. It was very easy, especially where you're in at-will employment jurisdictions like Pennsylvania. And I know we're going to talk more about that. But now we're starting to see a few more protections that employees have. And I think we're kind of in a weird spot where employers feel that they can still fire at will, and employees feel that they can say whatever they want without repercussion. But I think we're finding that somewhere in the middle is where the reality is today. And I think as we go through today's presentation, we'll try and cover all the topics, at least generally, if we can, all the topics where employers can try to get more of an understanding of what they can do to employees, and employees can get a better understanding of what they can and cannot say on the internet, and try and knock down some of these misperceptions. And
it's interesting, just from an HR perspective, when in the case where you are terminating someone, the employer looks at that as a private conversation. For sure. That's between the employer and the employee. And as we're finding, just because you go into that conversation with those assumptions doesn't always hold true for anything that happens after that conversation, as far as what folks can post out there, what they will say about the overall experience.
Absolutely. And I think that that's a real reality that employers have to accept now, that conversation regarding what takes place in the workplace will spill over onto the internet. And we need to think about that from the hiring process. I mean, I've had lots of cases where employees have come in, have done wonderful job interviews. They leave, they go right on social media and they bash the company or the person interviewing them, or they say, I lied during my entire interview. I've had those. We've had situations where employees are, maybe given a severance package in a downsizing or layoff situation. And before the package is completed and the payouts are made, they go out and they bash the company. They say that things that are untrue. Sometimes those employees lose their severances as a result. And this is occurring every day. Yesterday, the big story on the news, and we all know now that every time there's a social media story, it's like live at 5, big story, right. Social media. But in Florida, this one's very interesting. A appeals court ruled that an employee breached their severance agreement because there was a confidentiality provision in there. That employee told their daughter, and you're typically permitted to talk to your family members, right, about a severance package. And the daughter went out on Facebook and started bashing the company. My dad won, et cetera, et cetera. And the judge ruled that that was a breach of the settlement agreement. And as a result, the employee lost their severance. Wow. So this is occurring from hiring, discipline, and firing. And employers, I think, really need to be to accept that the reality of this world is that what happens in the workplace does and will spill out onto social media.
Interesting. So all this being said, I guess it comes down to, and Todd, you can certainly speak to this with all the recent developments that are out there when it comes to employers monitoring or trying to get a handle on what is taking place with their employees and social media.
Yeah, this is a really interesting area because as we're going to learn, if you don't know already, as we go through the afternoon here, employees are using social media to talk about every aspect of the workplace, as we've just said. So as a result, employers are finding themselves in an interesting position. Do they monitor? Do they not monitor? Can they practically monitor? Is it almost impossible to monitor? I think these are the things that are bouncing around every single day. What I have found, certainly in practicing in this area, is that we know one thing for sure. Employers absolutely have the right to monitor. They absolutely do. I think that employees have to understand that what you put on the internet is not private. You'd be surprised the number of cases I have where the employee says, that thing I put on Facebook, that was in the privacy of my own home. I posted that on the internet. So I think that, employees have to accept that there's no reasonable expectation of privacy in what they put out there via social media. So employers do have the right, certainly in Pennsylvania, to monitor. So the question becomes, should they monitor? Well, years ago, the biggest concern that I saw was that employers were monitoring what people were doing, but they weren't necessarily following up and taking action based on what they found. That's a real problem, because if you're out there and you're monitoring your employees and you're finding out that there's for instance, some harassment going on via social media, and then you don't take action.
Right. Isn't that constructive knowledge?
Absolutely. It's actual knowledge.
Okay.
It's not even constructive.
Okay.
It's actual, because they're reading the post. Exactly. And so I think that's where employers kind of got concerned. But I will tell you, I've seen a real shift in the last few years where more and more judges are almost putting an obligation on employers to start looking at this stuff. And, it really came out of the workplace violence world. We found that there was not almost, but a very large percentage of workplace violence situations were could have been stopped if the employer had been out there looking on the internet and found that some of the posts that this person was doing were getting a little disturbing. Had they looked at those posts and maybe jumped on it a little bit earlier, they could have prevented a violent situation in the workplace. Same thing is true with harassment and discrimination. We have many examples where it starts via social media and spills over into the workplace. And so courts have gotten kind of savvy to look at that and say, who's in the best position to stop this? It's the employer before it comes into the workplace. So you got to be out there looking at it to be able to stop it. The problem, though, is really practical. How does an employer monitor what employees do on a daily basis via social media? It is absolutely impossible to get it perfect. So I think as an employer, you have to find the right balance. You don't want to find yourself in a courtroom and saying to a judge, we never look at this stuff. We never look for this stuff. You want to do as much as you can based on your resources, how many employees you have, the dollars that you have to throw at sophisticated software to be able to catch this stuff, and try to do something. I try and get my clients to do something at least.
And now, Todd, from an IT perspective, it is fairly easy to put, some roadblocks in the way, such as filters that can just block, different pornography websites, gambling, things like that. But when you're not blocking the actual social media sites, you have to monitor the content. And so that content is really hard. Now, you had said, kind of based on your resources, but can you give us any kind of insight onto a best practice? Should that be a function of an HR or marketing department to kind of look up, hey, these are our employees. These are who's on Twitter. These are who have public Facebook profiles. These are who have public Instagram, things like that. And kind of, every once in a while try to kind of keep tabs on those things. Yeah,
in the ideal world, if you're a judge sitting back and look at this, ideally you want to make sure that an employer is looking at everything your employees are doing via social media. But we know it's virtually impossible. I do think that depending on your resources, if you have the personnel to do it, I do think you should be doing some sort of monitoring, whether it be searching Google searches for your employees that are active via social media, whether it be searching your company name, and you should be out there searching your company name quite routinely, whether it's to catch social media comments or to see what your customers are saying about you or your competitors are saying about you, to make sure that confidential information isn't being leaked or your company's being disparaged. It's very important. The one thing I will say that I'm nervous about from a legal standpoint here is that I really think that whoever is doing this search should not be a decision maker when it comes to deciding terms and conditions of employment for these individuals. And here's why. Oftentimes, if you're out there doing a social media search, you're going to find things that arguably would reveal protected classes for individuals. I've had cases where somebody's out there doing a simple Google search about employee and they see that they've been attending AA meetings. So now they're a rehabilitated drug or alcohol user, which has some protection under the Americans with Disabilities Act. If you want to then discipline that employee for a workplace performance issue, that employee, if they find out you've been looking at them, they're going to say, you're only taking action against me because you found out that I'm a rehabilitated drug or alcohol user. So I think you want to set up some sort of wall in the company where somebody who's monitoring is not participating in the decision-making concerning terms and conditions of employment for employees. The other danger, and maybe even the biggest danger, is that there's a lot of misinformation on the internet. So if you find something about an employee that's particularly troubling by doing this search, I really recommend that you confront that employee and talk to them about this before you make your decisions.
Can I just add one thing in? What about off-duty conduct? Because just let's say you do a search and you see something and you think, wow, that's surprising, and that maybe is not the type of behavior that I would want representative of my organization, but that behavior could certainly be legal. So how do you kind of separate that? And if I understand correctly, that in some states there are, more, or the laws are a little bit more strict or maybe more lax, but it really is handled state by state.
It is. There's a lot of states that do have statutes that prohibit employers from taking action based on off-duty conduct. We don't have that problem in Pennsylvania, so we're allowed to take that into consideration. So you run into an interesting balance because, there are some clients of mine who would see a picture of somebody at a baseball game drinking beer and have a problem with that because based on the business that they are, who their customers or clients are. There are other clients that wouldn't care about something like that. So you first have to make a decision of what type of employee you want in the workplace and what concerns you have in terms of perception of your clients and customers. You are permitted as an employer in Pennsylvania to decide to look at a picture like that and say, that's not the kind of person we want working here. And I've had cases where you could look at a picture that seemingly innocuous to some, but to this one employer, it's very disturbing. That employer actually can, in Pennsylvania, take action and say, we saw you drinking a beer at a baseball game, don't really want you working here. Now, they can do that. The problem that we run with social media, monitoring, taking action against employees that use it, trying to stop them from using it, is that employees won't want to work for your company. In this day and age, we have to acknowledge that the workforce that's coming out of school today cares much more about their use of social media than they do the workplace and their jobs. They're willing to move on to the next job that will let them use social media. If an employee base starts to realize that this employer is going to terminate them for having a beer at a baseball game, those employees are not going to want to continue to work at your company. And that's something employers really have to be very practical about today. They have to have some sort of tolerance of their employees being out there on social media. I mean, oftentimes pictures are out there of your employees that the employee didn't take. Right. A person in the next row took it or a friend took it and posted it without the employee knowing. I have employer clients who have fired over things like that. Other clients of mine look at it and go, I can't fire over something like that. No one would ever want to work here. Right, they feel like it's Big Brother.
Right.
And they feel like they're being watched, 24/7. Ironically, they're on the internet 24/7, but they don't want to have their terms and conditions of employment affected by it.
Okay. And Todd, yes, that reminds me, I saw an interesting statistic. This was actually from The Blaze, www.theblaze.com. They were saying that 53% of millennials, and this is the generation, I believe, I want to say, is it 82 to 2004, somewhere in there, the 80s to early 2000s, 53% of these folks, when they did the survey, said they would rather give up their sense of smell than lose a device connection. So just it furthermore just puts that reality in front of you as an employer. It says here, the desperate need to be connected overrides the desire for their olfactory receptors to function. And also goes on to say that a third of them would rather have this flexible work environment and access to social media than even a bigger paycheck. So it goes on to also talk about that it says these technology-obsessed workers, they actually use their devices 7.5 hours per day. So Again, the reality is that these folks are checking their Facebook page, sending emails while at work, most likely.
Well, I don't even think it's most likely. I think employers have to accept that they're doing it. I really do. I mean, years ago, again, we'd have these policies that say you can't do any social media or internet work while you're in the workplace. You can't. You will be fired if you try to go on the internet and try to look at a Facebook site or go to Amazon or shop or read the news. I mean, most employers are moving to incidental use policies to recognize the fact that your employees are going to do it. They're going to do it on their smartphones. They're going to do it on their tablets. Most of them are not even doing it through the company servers anymore because they feel that that's the most easy place that an employer is going to monitor what they do. So they move to their personal device. They're doing it on their phones, their tablets, to avoid being monitored. So it's not even happening on our servers much anymore.
So that last bullet point there, where it talks about employees, if they are using their own personal devices, let's say they bring in their smartphone, they're using the company Wi-Fi. Does the employer have any recourse for accessing those personal accounts because they are using the company equipment, i.e. the Wi-Fi?
Well, there's a few issues that sort of run into this. I think from a liability standpoint, a lot of employers are struggling with the idea that their company information is on a personal cell phone now. And they're prohibiting employees from downloading company information onto the phone. Some are blocking it. But the reality of it is, a lot of employees are using their personal phone to get email from the company, to look at Facebook, to send tweets out via Twitter. Again, I think employers have to kind of come back to the reality that we need to focus on job duties and responsibilities. If an employee is out there using their smartphone on the company Wi-Fi to check Facebook or to email their son or daughter in college or to shop or anything like that, the real question is that interfering with their work? Are they still getting their work done? Are they still interacting with their coworkers and their customers in the right way, in the proper way? That's what employers have to focus on today. Could
you make the argument that you might have happier employees if they do have the opportunity to check periodically?
Oh, I think it's a solid argument. Mm-hmm. I think the employee that is restricted from sending a Facebook post to their kid at school is certainly less happy than the employee who takes 3 seconds to do that. I think you will find statistically, and probably everyone listening to this has had this experience, the employees that abuse that are on their phone too much, the 7.5-hour day people, they're probably not getting their work done. Mm-hmm. How could you possibly get your work done and do this all at the same time? Right. So again, employers have to just focus back to the job duties and responsibilities and discipline accordingly.
I was going to say one last point in terms of, employers used to take the stance of no social media, but now it would almost be two-faced to say that when almost every single company pushes out, hey, come to our webinar on Twitter, on Facebook, on LinkedIn, things like that. So when you're actually kind of encouraging people to access information about your company via social networks, it seems like it would only make sense to allow employees to engage in that manner as well.
Yeah, it's a great point. A lot of employees throw that back to the employer all the time. So you told me to be on social media, to be active on it. And I think that's a really good point because one of the things we tend to focus on in these sessions, and lawyers are notorious for this, we focus on the bad stuff, right? But the truth is a lot of employers have had tremendous success in their business by encouraging their employees to tweet about the company, to post about the company. And so again, you got to almost take a step back as an employer and say, whatever we were in the past, we got to throw out. What do we want to be in the future? Are we going to embrace social media, which is the way of the world, or are we going to fight it? And I think for those employers that have found the right balance, I think it's worked for them. You can still discipline, and we're going to talk a lot about that, you could still discipline employees who do inappropriate things via social media. But for those that are out there and are being responsible and possibly saying great things about the company, I think you want them out there.
So as far as, again, what recourse the employer has, Todd, you mentioned earlier about at-will employment. Can this maybe be something that comes into play here to the rescue for the employer? Many states, including Pennsylvania, are truly at will, where either the employer or the employee can end that relationship at any time for any reason. One of the things that you do here whenever something in social media makes the news, and if there's a backlash or pressure as far as the rights of that employee to express himself or herself, many times people will invoke that constitutional right under freedom of speech. I'm sure you can comment on this for us as far as any differences between, public versus private employers.
Yeah, this is a really great question because it's very prevalent even today. A few years ago, there was a case here in central Pennsylvania where a number of nurses were fired from Pinnacle Health, and they were fired primarily for criticizing or making fun of patients. Although anonymously, they were making fun of patients via social media, and they were fired as a result for having poor judgment in doing so. At the time, I remember being interviewed by the news on television, and I made the comment that there's no freedom of speech in the private workplace. And I was highly criticized for that comment. Everybody got nuts. What do you mean there's no freedom of speech? We all have freedom of speech. We're Americans, Constitution, et cetera, et cetera. The reality of it is that, yes, do you have freedom of speech to say whatever you want on the internet, whenever you want to say it? Absolutely. So if you want to go out there and criticize patients or make fun of patients, go ahead and do it. You have the freedom of speech to do that. On the other hand, the employer does not have to employ you if they do not like what you're saying. So that's why I say your freedom of speech stops at the front door of the private workplace. The employer can look at those nurses and say, you have the right to do that, but we have the right to say we don't want you employed by us. And I think that's the biggest misconception in social media that has been out there since social media was invented, because employees feel that they have some protection that they truly don't have. Now, in the public sector, it is a little bit different. They do have some constitutional protections that could kick in if they're talking about a matter of public concern. They may have some protection. And again, even those employees lose their protections quite a bit because they don't quite meet the tests. But in the private sector, absolutely, there's no freedom of speech.
So, Todd, it almost makes me think it's akin to using that nurse example. If they, let's say they were physically in the presence of, the boss, and they decided to, or they chose to make fun of the patients at that moment. Certainly, I think the reasonable expectation is that you could not do that and expect to have a job at the end of the day.
Absolutely. I think a lot of employers look at what's being said social media and say to themselves, if that was said in the workplace right here, would I tolerate that? And the answer is typically no. And I think on the flip side, I think that's part of the reasons why we're all sitting here today. It's very easy to go out on social media or even text message or email and to say something about somebody that they wouldn't say to their face or to another human being. And I think there's no filters for people anymore. They shoot off text messages. They shoot off tweets very quickly. They post things to Facebook very quickly. They don't think it through. And there's like no inhibition. I mean, they just will just talk freely without thinking about the consequences.
Just reactive. So, Todd, I think a trend that we're seeing here is that there are indeed exceptions to the at-will clause. One of those is the National Labor Relations Act.
Yeah, I think this is really the hottest development in social media and the one that employers really need to pay the most attention to. Again, if we go back in time, when an employee said something on social media, very often the employer would be able to terminate without any sense that there could be liability on the employer for doing that. Well, the one area that we're really chipping away at this at-will doctrine is the National Labor Relations Act. The National Labor Relations Act is a federal statute that applies to both union shops and non-union shops. And what it basically does, among other things, but it has a provision in there under what's called Section 7 that basically says that if employees want to organize in the workplace, they should be able to do so without interference from the employer. In other words, we are supposed to permit employers who have unions and don't have unions, we're supposed to permit the employees to have a right to organize in the workplace. And again, it's very easy to look at this and say, well, I don't have a union in my place of employment, so I'm not going to worry about any of this stuff. More often than not, the cases under this National Labor Relations Act are against employers that don't have unions. And let me give you a couple examples here. So if employees are out there and they're on social media and they're talking about the terms and conditions of employment with their coworkers, and let's say they're complaining about wages, or they're complaining about hours, or they're complaining about the job duties and responsibilities in the workplace, an employer has to think twice before they move to terminate an employee for talking about these things openly, under the theory that maybe these employees are organizing a union. Who knows? But we should let them have that conversation. So the NLRB has quickly figured out that this is an area that employers are sort of still struggling with, and they're monitoring very closely these types of postings. If an employer takes action to terminate or discipline an employee who's out there complaining or talking about the terms and conditions of employment, it could be considered an unfair labor practice charge. And again, this is mostly happening with employers that don't have unions in the door already. And so it's one of the areas that I spend a lot of my practice in, because again, my clients would look at Facebook posts where employees are talking back and forth and just say, hey, let's get rid of them for doing that, not having good judgment by doing it on the internet. Now I have to tell them, put the brakes on a little bit. Let's analyze what they're saying. Are they talking about the terms and conditions of employment, pay, benefits, working conditions, etc.? And then there's a couple other tests you have to use to see whether or not they're protected. A big one is, are they really talking to coworkers? You know, if an employee is out there on the internet and they're talking about terms and conditions, but they're not really talking to their coworkers, they're talking to their 1,200 quote unquote friends on Facebook, which is mostly their family members, college friends, high school friends, etc. The National Labor Relations Board is going to look at it, and so are the courts, and say, you're not really organizing your coworkers. You're just basically griping about the company to your friends and family. So I think that's an important one. Also, I think that the employees have to be very productively saying, what do we do about this? We don't like the terms and conditions. Should we meet and talk about it further? Should we take some sort of action? I mean, it has to be productive. It has to really be productive. And so I'm telling employers to take a step back and really look at this and analyze it properly before you fire someone for talking about terms and conditions on the internet. And in terms of things that aren't protected, this is a really interesting area that we tend to work in. So if somebody's out there and they're complaining about a supervisor, the issue becomes, are they merely griping about a supervisor? Are they out there saying, my boss is tough, I don't like working for this person, they're kind of nasty in the morning? Are they doing that, or are they talking about, my boss makes me work late hours, didn't pay me overtime, makes me do this one job duty or responsibility that I think is outside of my job description? So are they griping about a supervisor, or are they talking productively about terms and conditions with their coworkers? If it's the latter, they have some protection. They can't be fired for that. But if they're just griping, they can. And just to give you an example and flesh it out a little bit, I had a case recently where an employee went out there on Facebook and said, I am upset because I had to come back to work and miss some of my vacation for a mandatory meeting. But then the employee, so you would look at that and you'd say, does that have some protection? Well, maybe they're talking a little bit about the terms and conditions. But then the employee goes right on to say, I'm so mad at this company, I'm going to get them when I return to the workplace. Now, what does that mean, get them? To an employer in the year 2014, that could mean something really scary, or it could mean I'm just not going to turn in this documentation, or I'm going to be mean to people. Who knows? But the employer, rightfully so, didn't tolerate that threat. And so when that case is litigated, the analysis is, while they may have had protection by saying, I don't want to come back from my vacation for work, they lost that protection immediately when they threatened the company. So we have to be very careful and look at these Facebook posts line by line to see whether there's protection or not.
And so can you give any tips for employers in what to take into account when trying to craft a policy of some sort?
Yeah, it's really an important thing, because when you're investigated by the National Labor Relations Board with respect to these issues, the first thing they're going to want to see is your policy. And they're going to want to see how restrictive you are on the employees. I think it's very tough these days to tell the employees they can't friend coworkers or talk to their coworkers via social media. Because what you're really saying to them in the NLRB's eyes, don't talk about the workplace. We don't want you getting together. We don't want you talking about terms and conditions. So from the NLRB's perspective, you can't be out there telling coworkers they can't talk to each other on the internet.
Right. I think I saw the phrase chilling, if the policy has a chilling effect, which I find interesting, because to me that's just it's overly broad.
It's overly broad. It's a struggle because I think that, employers want to be responsible and they want to make sure that employees aren't out there griping about supervisors publicly and not giving the supervisors a fair shake and maybe portraying the company unfairly. On the other hand, this type of lawsuit, this National Labor Relations Act Section 7 lawsuit, is the hottest one in our country right now. Most savvy employees know that if they're fired for posting something on Facebook, they're going to seek an attorney and try and see whether they have a lawful claim against the company based on this conduct. So the NLRB says you got to let your people talk. And I kind of find, practically speaking, that for my clients who let their employees talk on the internet, and let's say that they find that there is something that the employees are unhappy about with terms and conditions, well, I encourage my clients all the time to have that conversation in the workplace. Tell the employee, I noticed that you and your coworkers are upset about this pay or this. Let's talk about it. Mm-hmm. Let's get in. Let's air it out. Let's see if we can find a solution. That's the way that employers beat unions in the workplace forever.
Right.
So why not continue to do that? Don't get out there and just try and stop them from talking on the internet. Try and bring it back into the workplace and have a productive chat.
Would it make sense to put such language in your policy?
Well, I think that, if you ask the NLRB, they'd want you to be very, very open and say you are permitted to talk about this, 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 and this. Most of my clients are a little nervous about that. They don't want to give a roadmap to this stuff, to be perfectly honest. Yeah. But I think if you go out there on the internet, and I don't have the slide off the top of my head, we could probably find it here for this presentation and put it on the slide. But the NLRB actually has a suggested policy that employers should use in this situation. And I have to tell you, it's not as bad as you may think for employers. I looked at it. I've encouraged a couple of employers to push themselves a little bit and use that kind of policy. So I think that if you're listening to this webinar and you've had a policy with respect to social media and you haven't updated it in a few years, you're going to have to update it, especially to take into account these kinds of cases.
So, Todd, would it make sense when you are crafting that social media policy and really any other policies that talk about employee communications in your handbook, would it make sense to encourage employees to, if there is a problem or if they have a gripe or a beef of some sort, that they do reach out to their supervisor as a first step? Yeah,
I think that's a great practice. I think you're very careful when you write a policy like that to make sure you don't appear that you're coercing them not to talk to their coworkers before coming to, a supervisor. But I think, having an open door type policy that, we encourage all of our employees to bring any concerns, comments, et cetera, to the attention of management at any time is step one. I like that. But as you probably know, being an expert in what you do, policies are only good if you actually put them into practice. So I think the more important thing is that the employer actually is that kind of employer. They do have an open door policy. They do have a situation where employees do not feel uncomfortable approaching management to complain about things. I mean, honestly, I think back over the years I've practiced, and a lot of my clients who have who do not have unions in the workplace, the reason that they don't is because they have a happy workforce. They have a happy workforce who feels that they have a voice. If they have concerns or complaints, they can air them. They get attention. And, that goes back to like employer 101 basics, in my opinion.
Just creating that environment of respect.
Absolutely.
So earlier, Todd, we were talking about employers and taking a look at what activity is out there on social media. In fact, even when folks apply for positions, do you think that folks really, truly understand that employers are going to be out there kind of trolling and searching for information about folks, whether they're employees or even applicants?
Well, I'm sure that, we're becoming better as a society and recognizing that this is happening. But the reality of it is, my sense is that a lot of applicants really don't think it through. And this is really just kind of proven out by the number of cases I have where the employer does an interview and then goes out and checks the employee and finds things that you just wouldn't believe an employee would leave out there or an applicant would leave out there. It was obvious it would disqualify them from this position. So I think that there is still a problem with employees. Certainly younger generation employees coming out of college aren't really thinking about that post that they made while they were in college or that picture that they took and how it could affect their entire job, their entire career could be affected by that. I do think there's a bit of a problem with that. some employees get it because I have clients and I've seen clients who have on their applications a question that says something like, what social media sites are you active on? List them and tell us how many users you have. Some of them are even saying that because the employer wants to maybe encourage their employees to be on social media, to say good things about the company, et cetera. But you'd think that an employee who's seeing that question on an application would realize this employer is really interested in this stuff and may look, and yet, some don't. When social media started to become very, very active, a lot of employers would not only just say on their application, tell us what sites you're on, they'd actually ask for passwords.
Wow.
And this really rocked the applicant community. The employees said, wait a second here, this seems a little too much into our privacy, too much into our private world. And there were lawsuits that were pending over that. And in a lot of situations, the employer, either because they were ordered to take that question off an application or because they felt the public pressure or they weren't getting applicants to come to the company because they didn't want to disclose their private information, they pulled that off the application. The area that we see it pretty much exclusively now, where it's still very lawful and expected, to demand passwords, is, sometimes in the, maybe like in the teacher setting or something like that, if someone's particularly active. If you think there's a real potential for liability, maybe you'll be able to ask that question and look through someone's private account. But for the most part, a lot of states have enacted laws to prevent this from happening.
Getting back to the fact that folks, when they are posting, a lot of this, I guess, depending on how they have their settings established, for example, within Facebook, a lot of this could be private or could be public information. I saw an interesting statistic. This was on the Huffington Post on the website, where there was an article citing that 25% of Facebook users don't even bother with privacy settings.
Yeah, this is as a litigator that does employment law cases, this is a great area for me, because when I have a case filed against one of my clients, let's say it's a discrimination case or harassment case, the first thing I do is go out on Facebook and I look at the plaintiff, I look at the employee, and I try and get all their posts and see what they're saying about the company or about this specific situation. 9 times out of 10, that's very public. They haven't marked it private. I'm able to get it. And I've had, a case that really sticks out for me is I had a sexual harassment case a few years ago where this individual was claiming that they were sexually harassed in the workplace and that the things that they said were very inappropriate and offensive to them, and they didn't like to joke about sex or talk about sex in the workplace. And sure enough, I went out there on Facebook and found that this person not only talked about those types of things, initiated that conversation herself, brought it up when others weren't bringing it up. And when we sat in her deposition and she kind of denied, ever engaging in this type of communication, the last question of the day, I brought out a stack, 6 inches thick of her Facebook post. And she had no idea that we had those.
Wow.
That afternoon, she marked her Facebook page private, but before that, she didn't. And that's a real problem. A lot of employees don't know that. And so employers are going out and looking at this. And again, to go back to what we said at the very beginning, some employers feel an obligation. If there's an employee out there that you're considering hiring and they're out there said some pretty disturbing things on the internet, do you want to bring them into the workplace and subject your other, workers or your company to liability? That's something employers are really wrestling with.
And we're going to be posting a couple links on our website in the recap post with some best practices. There's a few guides on, how to set up your privacy settings. It's just good for users to know that these companies, Facebook, they're really advertising companies. How they make the majority of their money. And by being able to target their demographic more, that's how they make more money. And so it's actually benefits them for you to be more open, to overshare things. And so they're trying to push you that way with changing settings frequently and things like that. So even if you have changed your Facebook settings once a few years ago, it's something that you really need to keep up with because they're constantly changing their terms of service and their settings.
Yeah, it's a great point. And also another kind of warning to people out there who think that this stuff is private. If you file a lawsuit against a company, we as defense counsel are permitted to get every Facebook post you've ever done from the beginning of time. Not that we get it through Facebook, because they fight that quite a bit, but there is an option within Facebook where a user can download all of their posts into a PDF type file that you can't tamper with. And we as lawyers are permitted to ask the other side to do that. And so a lot of people don't realize that every Facebook post, everything you do on social media, we do and will get in the context of a lawsuit. And that's something people need to think about from day one.
Wow.
So really nothing is private.
Nothing is private on the internet.
So, Todd, again, we've talked about the National Labor Relations Act and how that it looks like the law at this point is tipping in the favor of the employees. I've also heard about another law called the Stored Communications Act, which again seems to provide some protective measures for employees when they do post.
Yeah, it's interesting. This is a federal act that's been around for many, many years that was really designed to prevent hacking. You know, when computers started to make their way into businesses, it was designed to prevent people from hacking in and to impose civil and criminal liability for those who tried to do it. Well, now we're starting to see it gain a little bit of traction in the social media world. And normally I wouldn't be concerned, but I am concerned because there's criminal liability for this kind of thing. So basically what that act says is that employers can't go looking into private accounts of employees unless you're authorized. That's basically what it is. And the way we see it playing out in the private workplace is that, I'll give you the classic example. The classic example is the supervisor comes in, gets their cup of coffee, and an employee comes in and walks down the hall, shuts the door and says, listen, I just want to tell you, Joe's out there on Facebook and he's really bashing you. And he's bashing the company, and I think you need to take a look at this. Well, the supervisor says, well, I'm not a friend of Joe's on Facebook, so are you? Can you let me in? Can I go look at this? And the employee says, sure, no problem. I'm gonna open it up and let you take a peek. Well, that's a problem for me now, because even though the employee that comes in with the information seems very open and they're volunteering to show the supervisor this information and to open up this account for the supervisor, I'm concerned that some courts are starting to look at that as a coerced action, whereas the supervisor, by even saying, can I look at it, or, I'm interested in seeing that sort of thing, could be perceived as coerced, and that you have unauthorized access to that employee's account that the supervisor didn't otherwise have. That's my biggest issue right now. I'm really working with employers to understand that if somebody comes to you with that information and says so-and-so is talking about you on the internet, and you don't have access to it already because you're not a friend of theirs, or have access because it's just public, I don't want you asking anybody to open it up for you. I don't want you asking anybody to print it out and bring it to my office. I don't want any of that, because that could be seen as coerced, unauthorized access. So what I'm really suggesting to supervisors and employers is this. If you are aware of that information, you always have the right to call the employee into the workplace, into your office, and say, I heard that you're saying this about me. That employee certainly may tell the truth, or maybe they don't. But you as a supervisor are allowed to look at the evidence, look at the facts, and say to yourself, I believe this employee over this one. And you know what? I'm going to get 3 more employees that are also going to tell me you're out there saying this. So you don't need to see the post. You don't need to ask for it. You can simply act on the information that you know. Same thing as if an employee came to you and said, Joe's talking about you in the coffee room. Why is it any different? You wouldn't need written proof of that. You could terminate Joe or discipline Joe for talking about you in the coffee room. So resist that urge as a supervisor to want to see it, ask for a printout, want to gain access to it. Now, I will tell you, if you walk in that day, you're the supervisor, you get your cup of coffee, you walk in your office, and on your chair is a printout of a conversation that you didn't ask for, you didn't talk about, it just shows up, you're perfectly okay.
Okay.
But supervisors have to be very careful, because the way the courts look at these things are that if a supervisor asks anything of an employee or implies that they want something from an employee, it's almost looked at as coercion, because you're the boss. They're going to want to please you. Whatever you ask for or imply and the employee does, they're coerced into doing it. So supervisors and employers have to be very careful about this. Again, because there's criminal liability for unauthorized access to accounts. Again, going back a few years ago, the way a lot of employers did this is they would create fake people on Facebook, and they'd go in and try and friend their coworkers with a fake name, fake picture, etc. Now, that was all fine and good until the Stored Communications Act started to get some teeth in this area. Mm-hmm. That is an absolute no-no now, and could be seen as an unauthorized access. So I do not recommend doing anything like that.
I seem to recall, and I know this law, the social media and the laws are just constantly changing, constantly evolving here. And I seem to recall a seminar that I attended where, using that example, where let's say, the employee comes in and, to tell the supervisor, hey, these folks are saying some really, nasty things about you in the organization, and they have that printout in hand. Here's the proof, supervisor. I've heard folks say that they recommend the employee sign or, make a statement to say that they've kind of freely handed that over to the supervisor. Any comment or advice on that?
Yeah, I always laugh about that advice because I get it. I do understand it because it's proof that the employee wasn't coerced or asked to bring it in. So I get that. But on the other hand, I've come across many judges who look at that and say, well, them signing that is coercion too. If you ask them to sign something saying that they prevented this to you freely, clearly they're coerced into writing that as well. So I would rather have it, but I don't know that it's going to rule the day at the end of the day. In your example, though, where an employee walks in and says, somebody's talking about you, here's the printout, I think you're good.
Okay.
Because you didn't ask for it. It showed up at the same time you learned that there was talk about you on the internet.
So rounding things out here as far as our topics, we talked earlier about so what is an employee to do? What exactly is safe? We've heard about things and precautions that we should all take, but Todd, any advice as far as what folks should be mindful of? Yeah,
I think the biggest one is really the common sense portion of this. For employees, you have to sit back these days and you have to think that whatever you put on social media is going to be seen by your employer, your potential employer, perhaps. It's going to be seen by your supervisors. It's going to be seen by perhaps law enforcement, perhaps a juror down the road at trial. I think, when we first started training in the email world, we told people to really think about it before you write and look what you're about to say. And let's remember that that's going to be saved and could be projected in a screen in trial, et cetera, et cetera. Same thing as social media. We've gotten so relaxed. It's so easy to send off a tweet that's, 140 characters and to do things very quickly without thinking it through. But employees really need to think about this. It doesn't go away. You send it out there. It's on the servers of the internet service providers, that's on the servers of Facebook, Twitter, Instagram, Foursquare. And again, as I said earlier, as defense counsel, we get these things routinely in cases. So I think employees really need to take a step back and be very careful about what they post. My biggest concern as of late is that while employees were very concerned and started to think about their emails, emails became very formal in terms of communication. Then we got to social media. It's less formal. They weren't thinking as much about it. Now we've gone so much into the visual media. For instance, employees are talking by just sending pictures back and forth on Instagram, and they're not even attaching text to it, that they don't think it through at all. But, as we said in some of our private discussions offline here, that, the picture tells 1,000 stories perhaps. And I think that this is where employees are getting themselves really caught right now. They're sending pictures back and forth that to them seem like no big deal, but an employer looks at it and says, what are you saying? Another great example, we didn't even talk about this, is the employee who takes pictures in the workplace. A lot of employers are concerned about this. Two employees are goofing around in the workplace and they're making trash can basketball game, and they post a picture on Instagram about it. And to them, it's no big deal. It's fun. Maybe they're great employees. To the employer, they could look at that and say, you're goofing off and you're showing the world that you're goofing off during the workday and we don't have a lot of work and you're not busy. So I think employees have to use common sense in thinking about the things that they post.
One of the areas, that example that you mentioned, we didn't even touch on this, but what about recording? What if those employees, they're goofing off and someone, records and posts that video now to YouTube?
Absolutely. There are tons and tons and tons of cases where employees are out there posting workplace interactions on YouTube. Tons of it. Sometimes they're out there showing their coworkers interacting. Sometimes is doing that, they're disclosing confidential information to the customer. I've had situations where an employee would post a video, and if you stop that video and you zoom in on the desk, you're going to see confidential information from a client or from that employer. So it's those kinds of things that employees are not even remotely thinking about the workspace. They're taking visual images of all their work documents and not even thinking it through. As we talked earlier, I think employees, not only do you want to think through what you say, you want to think about your privacy settings. To the extent you really do want to keep something private that you are saying, don't think that it's private just because it's on the internet and you're sitting at home typing it as opposed to being in the workplace. So look at your privacy settings and look at them often. As you heard from Reed, the policies are changing quite often. You may think you checked private for Facebook, but that was 6 months ago and the privacy settings have now changed. So you have to do it routinely. You can't make an argument that you have a reasonable expectation of privacy if you didn't take steps to keep your information private. They have to remember that. And lastly, I think it's important that as an employee, you know your employer's policies. Most employers have very sophisticated social media policies now that say what you can and cannot do, disclaimers you need to put out there. I think as an employee, if you want to protect yourself, you need to get to know those policies. Don't just throw the handbook in the bottom of your desk and don't pull it out. If you're active on social media, you should learn what the employer expects of you, because if you don't, you could be disciplined for that.
So moving forward here, talking about best practices for employers, what can employers do to mitigate the social media ever-changing landscape? I think one of the things from a proactive standpoint is that, and we were talking about this earlier offline, as far as maybe dusting off those policies and taking a look at what you have in your social media policy. I've seen policies where certain sites are listed. It's a pretty as inclusive, given the date that the policy is created, it's as inclusive as possible. But recognizing that the list is always changing, sites are born, they end. Todd, do you have any recommendations as to how to, get around that?
Yeah, I think that it's important to at least start off by naming some of the more active social media sites that we're experiencing today. I think if you look at even the list we had in the earlier slide, you're going to see a really good kind of survey of the types of social media sites that are out there. So I think employers' policies should say, these are the types of sites we consider to be social media, Facebook, Twitter, Instagram, Snapchat, Reddit. I think Pinterest, I think that gives them a good example of the different types of sites, but to make it also very clear in that policy that this is not an exhaustive list, it's not meant to be exclusive, and that this changes so frequently that you shouldn't take this list as the only sites we're concerned about.
So almost like including but not limited to
Absolutely.
Sorts of verbiage?
Exactly.
Okay.
That's exactly the verbiage you should use.
Okay. And you had mentioned before about, and I think Reed too, you mentioned about posting perhaps some resources for folks. I know Todd said that there's a really good model policy out there that folks could take a look at.
Yes, yeah. Definitely. We will be providing a recap of this webinar on our website in the next few days, and we will provide links to many of the source articles that we have talked about and kind of referenced.
Yeah. And as we talked about earlier, policies they're wonderful and they're important and they're needed in the workplace, but they're not really effective if you're not looking at them often to update them. And look, in the social media world, we're so far behind. A lot of my clients, still have email policies and that's all they have. So we need to move forward with that. Also, and this is one I'm very big on. It's very important that employers train their employees on this. Years ago, the Supreme Court really kind of put the hammer down on employers and said, if you don't train on your sexual harassment or discrimination policies, you're going to lose valuable defenses at trial if you don't do it. That was great. That made employers do it. The same thing is true with social media. I think it's very important to sit down with your employees and explain what your expectations are of them via social media and to explain to them what their rights are. And again, to knock down some of these misperceptions, which could save everybody a lot of trouble as we move forward. So training on these policies is absolutely key.
So Todd, we were talking earlier about employees who friend each other. And again, looking at best practices for employers, it does beg the question, what about those employees who have really good relationships with their supervisor and they choose to reach out to the supervisor on Facebook or some other site and friend that supervisor? Do you have any advice for what employers should watch out for or be on the lookout for here?
Yeah, absolutely. We talked earlier that the National Labor Relations Board would tell you can't say coworkers can't friend each other because they need to talk about terms and conditions of employment. But when it comes to supervisors, I'm personally very against them being friends with their subordinates, and really for one major reason. While I like to see good relationships in the workplace, I think that's very important. I'm concerned that when a supervisor is connected to a subordinate via social media, they then are charged with the obligation of policing everything that employee does via Facebook. So we all know that, practically speaking, an employee could post hundreds of posts a day, and a supervisor may not check their Facebook for 3 days. But if during that time period that employee engaged in inappropriate conduct, or was engaged in discriminatory behavior or harassment or workplace violence or something like that, and that employer didn't catch it, there's going to be some negligence to that supervisor. And it's not enough to just say, I didn't see it. You're going to be charged with having the knowledge, because if you're going to enter that world of social media and connect with your coworkers, you are then going to have the duty to look what they're doing all the time and to jump on it and remedy conduct that could spill over into the workplace. So it's a very dangerous thing. That's the one area that there has been legislation to prevent, again, teachers and students from being friends. And I feel the same way about supervisors in the private sector.
You're essentially on notice.
You are either actually on notice because maybe you saw it, or absolutely you have constructive knowledge because you knew or should have known that they were engaging in this behavior if you were being a little bit more diligent in checking your social media. So it puts just an incredible burden on the supervisor.
Sounds extremely risky.
It's extremely risky, and yet supervisors do it every day.
And would this extend to all social networks, not just Facebook? So in terms of, if you follow somebody on Foursquare or follow them on Twitter, would those fall under your same recommendation as not friending people?
Absolutely. If you're a supervisor and you are connected to somebody on Foursquare and that employee calls in sick for the day, and had you been checking your Foursquare, you would have seen that they were really skiing at Ski Round Top rather than being there. You would have missed that. And that could cause liability. So I think that it applies to every social media site.
Great.
The other question, too, or other comment, we were chatting about this offline a little bit, would be wage and hour issues. With the advent of social media and even with smartphones, we are all now very much connected to one another. And for those hourly employees who find themselves, checking their email via phone, does that raise some concern, Todd, as far as any wage and hour violations?
Yeah, it's a biggie. The Department of Labor is very focused right now on capturing time that's not being recorded by employees at home or on the weekends. And obviously cell phone use is a big one. If you're an employer and you have an employee who's non-exempt, meaning they're paid for all hours worked, and you know that they're out there working on their smartphone, technically speaking, you do have to pay them for that time. A lot of my clients have gone to the point where they've shut down their servers to not push out information to these hourly workers in hours that are outside their normal work hours, to prevent that type of argument that they were working. And just to take it again to the social media, the app world, I mean, the Department of Labor even has a free app that they have out there where they allow employees to track their off-duty hours. They download it to their phone, they keep track of their hours, they can print it, etc. So this is a very, very big area. Employers can't simply put their head in the sand and ignore what their employees are doing just because they're not in the workplace.
Should they go so far as to set up the policies that specifically call out those folks who, could be able to check email, remotely? Could it, provide steps for what they should or should not do?
Yeah, absolutely.
That policy?
Absolutely. A lot of my clients have policies that say for those non-exempt employees, here's, you're not to check your email, you are not to respond, you're not to this. But let's be honest, it happens. It happens. And I think that that's part of the issue. So I think, again, policies are great, but if you're not following them and your employee, your supervisor is still sending messages saying, respond to this right now, and it's a weekend, you got to be aware of the fact that you may be called to pay that employee for that time.
We do have some questions that came through during the presentation. The first one is, could you require that if you allow social media in the workplace that the employees must friend you? That would be the company or the supervisor. Todd, do you have any thoughts on that?
Yeah, well, we just kind of talked about that a little bit in terms of, I don't recommend a supervisor ever being friends with a subordinate. So, we don't want to get into the practice of requiring that. An interesting part of that question is, if a company has a page, let's say to promote the employer, Can you require your employees who are on social media to friend that page? Well, from a legal standpoint, there's nothing that says you can't. There's no law that prevents that. But, I don't know that I would, as an employer, want to force my people into doing that. I would want them to be on the site and to be friends with the company if they really believe in it, they're excited about it, they're positive about it. Forcing them into it could, I could see potentially result into them posting some negative comments about the company to the extent they feel coerced. So I really wouldn't recommend that.
Okay. Thanks for answering that. The other question we got is similar, kind of piggybacking on what you were just talking about, where Todd, the question is, should social media acceptable practices start at the top? That is, should management set the tone just as they would for maybe an ethics policy, anti-harassment policy, really anything for that matter? Yeah,
I think that applies to many different areas other than social media. But the one that comes to my mind with respect to this kind of question is, I've had cases through the years where supervisors kind of got sucked into inappropriate social media activity. For example, an employee would be on Facebook and would be sort of bashing that supervisor or saying negative things about the supervisor, and the supervisor would jump right on and discipline or fire that employee right there on Facebook, say, you know what, don't come in tomorrow if that's the way you feel. I don't really like that. I think supervisors should set the tone and should always be professional. What the courts and what juries certainly would expect of that supervisor is that you would take it offline and you would have a very professional disciplinary conversation with that employee outside of the social media world. And I think that's a really important tone to set. Also, I just wanted to add, and this was a question we received as well, do the things we're talking about kind of apply to LinkedIn and some of the other social media type or business related sites? And I think it does. I think you want to be very careful. I think in the LinkedIn world, certainly supervisors are more apt to kind of connect with employees because there's a professionalism to that particular service that you don't have with the others. But I will tell you, there's danger in it too. Certainly had at least one of these cases over the years, maybe two, where because everybody was connected, an employee was fired from the company. And they went onto LinkedIn and they were asking for recommendations for their next job. And some of the coworkers who were all connected and some of the other supervisors said, yeah, great hire. Go ahead and hire this person, which is directly contrary to the reasons why this person was let go from the company. And while that seems like, people could have different views, in a discrimination case, that would be enough to be what's called pretext, which would say something doesn't really make sense here. Let's let this go to a jury. So it actually has some dangerous legal, repercussions if you're all connected via social media. So, personally, because I see a lot of the risk and I see how this falls out, I'm trying to encourage my supervisors and even some coworkers to kind of connect with people offline, get back into personal relationships, face-to-face communication because of the risks here.
It's not documented and memorialized and forwarded on.
There you go. There's that too. I mean, let's face it. People are creating an entire track record of harassment, of discrimination, of wrongful discharge. I mean, it's quite dangerous.
All right. Thank you both for joining us. And for everybody that is attending, we have all of our contact information up here on the screen. And we will be posting a recap and recording of this webinar on our website at www.macpas.com. And we will be sending you an email letting you know when that's up and ready. We're also on the site going to have a list of all the links and kind of source websites that we got a lot of the statistics and information for. So hopefully you find that helpful as well. All right, we're going to sign off. So have a great afternoon. Thank you once again for joining us for this presentation produced by McKonly Asbury, Certified Public Accountants. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn about our upcoming events by visiting us online at www.macpas.com. Thanks again and have a great day.